SJC-11967, Commonwealth v. Thomas J. Gerhardt.
Field testing.
Morning, Ms. Jacobstein, you came back.
I had so much fun yesterday.
Good. Okay, let's see if we can match that enjoyment today. You may proceed.
Thank you, Your Honor. Rebecca Jacobstein for Thomas Gerhardt. We are here today on 4 reported questions from the Worcester District Court, and the questions are basically what evidence can come in a driving under the influence of marijuana case, and what can we assume that jurors know about marijuana consumption and driving. And I wanted to start with whether the police can testify to performance on the field sobriety tests. And the answer to that is no. And the reason is because field sobriety tests they distinguish between whether your blood alcohol content is greater than 0.08 or less than 0.08. What they do not test for is they do not test for marijuana use, and they do not test for driving impairment. If you fail the field sobriety tests because you have used alcohol, that is an indication that you are too impaired to drive. If you fail the field sobriety test for any other reason, it is an indication that you have failed the field sobriety tests.
Well, isn't all this disputed? There are some schools of thought about this.
There's no agreement in the scientific community right now about what the field sobriety tests show.
Okay, so this was a Lanigan hearing.
Yes.
And the purpose of a Lanigan hearing is to determine, I take it, is to determine whether or not somebody who is advancing scientific evidence that is not generally accepted in the community, in the relevant scientific community, may nevertheless offer that evidence because it's reliable.
Right.
Now, were there any witnesses who testified in this case?
Yeah.
There were 3.
Okay.
So
And did the judge make any determinations as to the credibility of those witnesses? Did he believe those witnesses?
he didn't.
And those witnesses testified for the Commonwealth, I take it?
2 testified for the Commonwealth, 1 testified for Mr. Gerhardt.
And the witnesses who testified for the Commonwealth suggested that, at least in their point of view and in their opinion, that the evidence of these field sobriety tests was relevant on the question of driving impairment caused by marijuana consumption. I mean, that's what they said, didn't they? They said that these were reliable indicators?
I think they said they were reliable indicators of marijuana use, and therefore that's an indicator that they were driving while impaired by marijuana.
Nobody in their briefs, I don't think, cited either Lanigan or Canavan's case or any of the Lanigan law cases.
I didn't, and then...
And the prosecutor didn't either.
No, she did not.
And so what are we to make of these questions, which don't really seem to address whether or not field sobriety tests may be used, at least in the view of some experts out there, may be used because they are relevant as to the issue of impairment in driving caused by marijuana?
Well,
can we answer that question based on the record in this case?
I think you can, because there is extensive evidence of a lack of uniformity. But also, there was...
It's generally, the scientific community is heavily weighted in your favor, I take it.
That's what I think.
Yeah, but it's not, there is an opposing point of view.
Well, I think what the opposing point of view is...
But my question is, there is an opposing point of view.
Well, not on HGN, I don't think. I think on the nystagmus, I don't think anyone thinks nystagmus.
But there's an opposing point of view as to the reliability of the field sobriety tests as to the question of driving impairment caused by marijuana consumption.
Right. Some people do feel that you can correlate the field marijuana, how you do on the field sobriety tests due to marijuana use and an inability to
drive. And the judge made no determination as to the reliability of those people who testified that they are reliable.
No, he didn't make any findings as to credibility or reliability of the witnesses. They didn't really testify huge lead across purposes. They all testified to their own.
But it, just at a, he didn't, but if you've got, so one answer then to Justice Spina's question, if you've got opposing views is, okay, they all come in, right? None of the, I mean, in other words, yes, the judge is a gatekeeper, but isn't that a possible answer here? But wouldn't you need the judge to do it? That from Lanigan's perspective, if you're talking about reliability, the judge might have said, both of these views, in my opinion, are sufficiently scientifically reliable to be put before the jury. Which one, if either, the jury decides is more persuasive is up to the jury. I mean, that could have been one result, right?
That could be, but what would absolutely have to happen there is that there'd have to be experts. It would not be sufficient for the police officer just by himself as the person who did the field sobriety test to come in and say, here is what happened, therefore that proves he was driving under the influence of marijuana.
But we're getting,
Well, does,
I'm sorry, go ahead.
But they can't testify to that anyway.
the police officers don't say, here's what happened, and therefore that's why I concluded the driver was impaired. No, I mean,
What they say is I
follow instructions, he couldn't walk in a straight line, he couldn't stand on one leg.
and then they say he failed the test.
Right.
Right.
And the implication from that, because we all know these are tests, and what they test for is impairment.
Well, coordination, dexterity, balance, ability to follow
Well, that-
instructions.
Right, that's what they test for.
Right.
But that's not what,
None of that's relevant to driving?
well, in the case of alcohol it is, because in alcohol, when the alcohol comes down, it just soaks all of your brain the same way at the same
So
time.
driver's coordination is not relevant to someone who's high on marijuana? Whether they are, I mean, I don't
Well,
understand.
the thing, here's the thing, is that if you can't stand on one leg because you've taken marijuana, that doesn't tell us how much marijuana you've taken, and it doesn't tell you.
Doesn't tell us how much alcohol he's taken either.
Well, see, that's the thing about it. It does. If you fail the walk and turn test and the one-leg stand test, what that tells us is that you have a BAC of greater than .08.
Who tells us that?
That's the scientific
So
studies.
but how's the jury informed of that?
Well, the jury isn't informed of that.
Right,
but the
and there's
jury
no
gets,
testimony on that score.
Right, but the jury gets to know it for that reason, because what they know is supported by the science.
So what is basically what you're saying with respect to alcohol. It is sufficiently undisputed at this point that the field sobriety tests correlate with impairment, and that they show impairment by alcohol. That's why you are not doing well on the test, is because you are impaired by alcohol, and the science is sufficiently undisputed that that kind of impairment by alcohol is likely to impair somebody's driving.
Yes,
right?
because they've done tests for both of those propositions.
And so we don't have to put in all the steps anymore. That's sort of in the general knowledge. So when the officer testifies, she failed the test, the jury just assumes that's telling me something about impaired being able to drive. And we
Yes.
say that's okay without saying anything because science says it's okay. And you're saying that's just not true here,
That's
right?
Right.
But is this a Dalbert Lanigan? I mean, Dalbert Lanigan speaks of the admissibility of an opinion, not the
Well-
admissibility of certain facts. Isn't this purely a relevance issue?
I think what turned it into a Daubert Lanigan issue is whether or not the average juror can be expected to understand marijuana use, marijuana terminology, and how its impact on driving. Because if you don't need an expert to testify, because everybody understands with alcohol what it does, then it's not a Daubert issue. But if you need an expert, then then it becomes a Daubert issue. Is it reliable? Is it scientifically validated?
I mean, I guess what I'm perplexed by is if somebody's stopped and the person is believed to be under the influence of marijuana, the police officer can testify he appeared glassy-eyed, he appeared goofy, he appeared to stumbled around, he had a craving for pizza. All that can,
Great deal about
all that can come in.
Well, see,
I'll ignore that last comment from my colleague. That all comes in.
I think you need an expert to bring that in.
So what can an officer testify?
Officer can testify to that. The officer can say, these were my observations.
Right, okay.
But not without an expert to also
Not
come in and
relevant in your
testify
view.
what those things mean.
But if we were to acknowledge that there is a body of science, that there is some science out there that says that failing the field sobriety tests, the standard field sobriety tests, together with other evidence of consumption of marijuana, is a reliable indicator that the person was under the influence of marijuana at the time of driving the motor vehicle. If we were to recognize that science, then the police officer could get up there and say, based on my training and experience, the failure of the field sobriety tests, together with the information I had that he had consumed marijuana, he was operating under the influence of marijuana.
No, because it's not scientific. There's no agreement in the scientific community that's
There doesn't
true.
have to be agreement. It just has to be reliable.
But it has to be reliable to have an expert to testify. That's different from a layperson testifying.
But the expert is the police officer now.
Well, but see, that's the thing, is that the police officer's not an expert. The DRE got up and testified that based on field sobriety tests alone, you can't figure out what a person is on. You
Who
need
said
the
that?
DRE the DRE that testified for Trooper McGarrian, who testified.
Can't figure out what the well, of course.
Right, and you can look at, of course, other indicia.
Yeah, like the smell of marijuana, like there are roaches all over the place that have been recently smoked. I mean, of course, he failed a field sobriety test. Therefore, I concluded he was on marijuana. That doesn't make any sense.
Well,
at
it
all.
doesn't, but,
This tests dexterity, tests the kinds of skills one needs to drive.
well, no, it only actually tests it doesn't actually test driving skills. What it tests is your impairment
Okay, what?
from alcohol.
Okay.
That if you are impaired to a certain extent on your ability to stand on one leg from alcohol, then you are impaired to drive. Those are two totally separate things. If you fail the one-legged stand because you have a health issue and you can't do the walk and turn because you're overweight, it's not testing your ability to drive, it's testing your ability to take those tests.
But I'm perplexed as to what observations of the defendant you say are admissible when the claim is marijuana.
When the claim is marijuana, what's admissible would be the police officer's observations, as long as they bring in an expert to explain that. The average
So you're
person-
saying that if the officer can't even say he appeared to be unsteady on his feet when he left the car, you need an expert to say that is probative of the use of marijuana before you can say he appeared to be unsteady?
Yes, because other courts have found that the symptoms from marijuana are confusing, and from all drugs, they're not. This particular trooper, the Trooper McGarrian, justified that everybody displays different. Everybody's different, so everybody displays different effects, and the average person doesn't know what is caused by marijuana. The average person doesn't know that whether marijuana makes you unsteady. I don't.
So the consequence of if we accept it, the Commonwealth could not prosecute anybody for under the influence with marijuana without calling an expert.
Right. For right now, they need an expert.
Can I just clarify? I mean, I'm trying to read through some of the things that were cited here in the recent studies. And so what you're saying, just because the tests currently for alcohol use look to things like saying the alphabet and walking in a straight line, if you think about it, a lot of people don't walk in a straight line, could really drive just fine, because it isn't about walking. After all, it's about driving and judging distance and being able to turn and stay in a straight line and, all these move quickly in response to other things in the road. And, of course, you don't need to know how to read unless you have to read a stop sign, but, they're universals. So it's about blood alcohol because there are scientific tests that have established the relationship between certain field tests as indicators, scientifically established, of the level of your blood alcohol. And that level can translate to impairment in driving.
Right, that's what
So
this.
is the same true? Has that been done with respect to marijuana use? So, apart from the studies that show, and more recently have been shown to establish that, yes, most of the world, apparently, it's the most used drug in the world, and everybody who uses alcohol, or a lot of people use marijuana and drive, but that hasn't increased any accidents, right? So is there anything out there that has established that certain behavior, apart from driving and crashing into things, because that's certain behavior on the side of the road reflects that you are highly intoxicated by marijuana, and that intoxication means you're not going to drive well?
They're working on it. The answer to that is right now, no, but they're working on it.
So I think that, part of what has, people I think they know what it looks like to see somebody who's been using marijuana. Sort of common experience that I think many people would feel that they knew what it looked like to say somebody's been smoking dope. And that, in a way, that's what most worries you, because if somebody is described as having used marijuana for these other reasons, you see this as connecting the dots to driving impairment. When you're saying is that people don't understand the connection or in fact, the actual impact of marijuana use on driving ability.
I'm certainly saying that there because the link between marijuana use and the link between the amount of marijuana that is required to cause the physical manifestations and whether or not that amount, it may be just a little bit, maybe if it does cause you to not be able to stand on one leg, maybe just one little smoke makes it so you can't stand on one leg anymore. If you're a chronic user, it makes it so that even if you're not using, you can't stand on one leg anymore for at least 20% of them. So those people can't judge. You can't say, well, how much have they done, and then how much is that enough to make them impaired? But I do contest that. I think that there is a stereotype as to, and kind of like what we all believe someone on marijuana is like, but I don't know that that stereotype includes how well you can then drive a car.
Did you agree? Do you agree that a police officer who believes somebody was driving under the influence of marijuana could administer field sobriety tests and say, for instance, that he was not able to do the one-legged stand and was not able to do the heel-to-toe turnaround? They could testify to that?
Testify to it or administer it?
Both.
Well, certainly they can administer it.
And how about testify to how the person performed on the test?
I think that here's what I think. I think they can testify to their observations. I asked him to stand on one leg, he couldn't do it. I don't think he can testify to a pass-fail on that test because it's not a test for marijuana impairment.
Wouldn't you also say, but maybe not, he could say he couldn't stand on one leg, but I thought you were saying before that if the Commonwealth wants to introduce that evidence, then it needs to put on an expert
Right.
to say not standing on one leg is relevant here because it's a signal that you can't drive.
Right, he could testify to it, but there still needs to be an expert. Because because the field sobriety test, right, that's a battery of 3 tests. And the HGN has been kicked out, so there's only two left, and the walk and turn is really shady. But at the very end, so all we have is this one-legged stand, and everyone seems to agree that use of marijuana will impact your balance. But what no one agrees on is at what amount and where then.
But is that the question? Isn't there expert testimony in the record here that says that the failure to pass the standard field sobriety tests is moderately relevant to the question of whether or not somebody is operating under the influence of marijuana?
There's certainly a study that says that, and then there's studies that say
And didn't the Commonwealth's expert testify to that?
I don't remember that, but you could be
Okay.
correct.
All right, thank you.
Thank you.
Good morning, Ms. King.
Good morning, may it please the court, Michelle King.
Before you get warmed up and get started, one question which I should know the answer to. When somebody is charged with OUI, does the jury have to determine what the substance is which is causing them to be operating on the influence?
Yes, Your Honor. When a defendant is charged with OUI liquor or OUI drugs, the Commonwealth has the burden of showing what particular substance that has caused the driver to be impaired.
So
However,
the jury must find that it was marijuana as opposed to cocaine or something like that?
yes, Your Honor. The Commonwealth may prove that, however, by circumstantial evidence, and as Justice Cordy pointed out, some of that circumstantial evidence could be the smell of marijuana. The defendant admitted that he had smoked marijuana. There was marijuana within the car. All of those things may be shown by the Commonwealth to show what type of drug or alcohol or whatever caused the
Is the
impairment.
complaint alleges whatever the substance is, whether it's liquor, marijuana, cocaine, PCP. Is that true?
It does, Your Honor.
And the jury must find beyond a reasonable doubt that it was PCP and not Percodan or cocaine?
Yes, Your Honor. Well, there are a schedule of drugs, and some of those drugs are lumped together, such as depressants or stimulants. But marijuana is listed within the statute separately. So it says,
In Chapter 90, Section 24, is that right? Is that where it's listed you're talking about? It's not 94C you're talking about?
no, Your Honor, it's under the OUI statute.
Just out of curiosity again, when it's something like Percocet or, one of the opiates as opposed to marijuana, is field sobriety testing also used in connection with those drugs?
Well, Your Honor, I think that's more of an open question across nationwide than it is with marijuana. Again, I didn't read all of the evidence with regard to drugs because we were limited with marijuana here, so I didn't really, to be honest with you, look at any studies that talked about the implications of different types of drugs with regard to field sobriety tests because we were limited to marijuana here. So I'm not sure that I'm really...
I just wondered if any of the testimony or if you're sort of in terms of experience, whether or not this is a technique used in the Commonwealth's proof with respect to those kinds of drugs as the substance causing intoxication.
I think, I'm not sure I understand your question, Your Honor, I'm sorry.
Well, I just wanted to know what field sobriety tests are used for other than alcohol.
Oh, sure. So field sobriety tests generally test a driver's coordination, dexterity, ability to follow directions, attention, such things like that. And all of the experts here, in this case, at the hearing, or at least Trooper McGarrian and Dr. Richmond testified that the field sobriety tests are tests such things as diminished capacity, divided attention, and things like that. And so they would also test presumably for other types of drugs. Again, it's then the Commonwealth's burden to show which type of drug, by way of circumstantial evidence, was causing that.
I think Ms. Jacobstein has a sort of two-part proposition. I just want to see if you agree at least with the framework of the proposition. Number one is that you need to be able, that for the Commonwealth to have police introduce evidence about performance on the field sobriety tests, there needs to be a scientific consensus that the field sobriety tests performance on the measure marijuana consumption, and also a separate consensus that the performance on the field sobriety tests, that the marijuana consumption that's measured correlates with driving capacity or driving impairment or lack of same. So it's a sort of two-part. Is that the same framework you agree with?
I would agree that, well, first off, I'll say that what's important here is that this evidence of field sobriety tests will come in if they have a rational tendency to prove some issue in the case. And so the reason why standardized field sobriety tests with regard to marijuana come in is because they do tend to have a rational tendency to show that the driver is impaired under marijuana. And so,
Could I just stop you right there?
absolutely.
With alcohol, at least I'm just repeating what Ms. Jacobson argued. With alcohol, it appears to me that the inference is there's no dispute on that proposition. It has a rational tendency to show that that's connected to driving impairment. If it's disputed, there may be that, let's say there's an equipoise in studies showing that has some people say, yes, it has a rational tendency to show driving impairment because of marijuana. There's an equally expert body of knowledge that says, no, there's no connection whatsoever. Do we have to wait until there's a consensus before we allow the police to testify without an expert?
No, Your Honor, I would suggest that that goes to the weight, whether or not, rather than whether or not it's relevant.
In this case, we haven't been presented with the question as to whether or not this science that was presented at this Lanigan hearing it shows that at least there is a body of science. At least there are some scientists who support the idea that the field sobriety tests are a reliable indicator of somebody's impairment to drive. Somebody is impaired to drive a motor vehicle because of consumption of marijuana. Was that decided in the lower court?
Well, Your Honor,
I'm somewhat surprised that question isn't before us now.
well,
Am I missing something?
Yeah, Your Honor, the four certified questions seem more to get to whether or not a police officer, as a late witness, has an opportunity to testify as to the particular signs and symptoms that a person who's under the influence of marijuana is capable of testifying to. With regard to the first issue, it's clear, I would suggest to you that the trial judge viewed Dr. Richmond as an expert on the issue of whether or not field sobriety tests are applicable to marijuana intoxication. It was very clear, in fact, the defense counsel challenged that at the lower court in the hearing, and he said, no, I find that he's an expert on this issue. And so the questions that he certified, I wasn't part of that certification process, but the questions that he certified more went to the issue of whether or not this testimony by a lay witness was relevant.
But what difference does it make if the science isn't reliable?
Your Honor, I don't agree that it does. I mean, I agree with you that that's not the issue before this court, and that's, you can have, so we're not looking at experts where they have to be, agree to a scientific certainty or that they have to have any sort of agreement. As long as the standardized field sobriety tests have some rational tendency to prove an issue in this case, then they should be admissible. And so I would suggest to you that the standardized field sobriety tests with regard to marijuana intoxication are relevant. We had testimony.
But they're only relevant if if the science, if they can be shown to have been a reliable indicator that the consumption of marijuana can impair one's driving ability.
Agreed, Your Honor.
As demonstrated by a failure of the field sobriety test.
Agreed, Your Honor. And I would suggest to you.
How do we know how do we know that the science is reliable, or that those tests are a reliable indicator of impaired operation?
Well, in this case, Your Honor, there was testimony. For one, there was testimony from Dr. Richmond, and I would suggest to you that
Was it accepted?
it was accepted.
How do I know that?
Because the motion judge certified him as an expert in the area of field sobriety tests with regard to marijuana.
But that doesn't tell you whether,
Well, the question is whether the judge made any findings with respect to any of this, and he didn't.
He did
just
not.
passed it on, took the evidence,
He
Posed-
handed it off to the appeals
Us.
court, and now it's yours.
took the evidence, you guys certified the questions, and it comes to us. All right, I understand
Agreed,
that.
and I think, well,
If you could turn to the issue of lay testimony as to whether a person is high on marijuana, we allow it in alcohol because we say people know when someone is drunk. We may know when somebody is high on something. Do we know whether the person is high on marijuana as opposed to something else?
I would suggest to you, Your Honor, at this point in our society, that marijuana use is so widespread, and I certainly cited in my brief that almost 20 million people in the United States, as recently reported, have reported that they have smoked marijuana within the last year.
Yeah, but, I mean, I'm old, so, but I really do think that there are some generational issues here, and I saw with some horror, since we're about to have a certified question on the ballot, but that teenagers report more marijuana use than well, they're both bad, but anyway, cigarette use. But if what may be true of 20-year-olds isn't necessarily true of, I'm thinking about jurors, 50 to 70-year-olds.
Yes, Your Honor. Actually, if you look at, in my brief, one of the things that I noted was that in Massachusetts, the percentage of people over the age of 25 who have themselves smoked marijuana, Massachusetts ranks 13th
It's
in the country.
smoking marijuana. It's like saying I've had one glass of wine. It doesn't tell me anything about what, it doesn't.
Oh, it absolutely does, Your Honor. If you've smoked marijuana, I would suggest to you that you know the effects of marijuana. And if you have a friend who smokes marijuana and is with you, and you're witnessed the effects of marijuana,
Wait a second, I mean, that's, I could have a glass of wine and be loopy, and, the person I'm with, not. The fact that, somebody who has smoked a joint acts one way doesn't mean that somebody else would respond in the same way. I don't think that's a...
Agreed, Your Honor, but if you had one glass of wine and you were loopy, you would know that you shouldn't be drinking and driving.
Yeah, but that's because she knew that she had drunk something. The problem is, I guess my concern is, okay, a lot of people have used marijuana during the course of their life, but there's not only marijuana out there. I mean, there's meth, there's a whole set of opiates, there's, you name it, it's it's out there. Can we say that people can distinguish the reason that somebody is high and say the person is high on marijuana as opposed to high on Lord knows what?
Well, again, Your Honor, part of that goes to, again, the circumstantial evidence that comes in.
Gotta be a
This
foundation
is
for
just
it. There's got to be a foundation for it.
Of course, and
I
of course there
observed
would be at trial.
Her with marijuana, the smoke was coming out of the car. I mean,
Absolutely.
that's the foundation.
Okay, but
Plus the physical.
You don't look at it in a vacuum. You don't just have the police officer's testimony to the symptoms without him saying that I went through this course, or you could even have a lay witness. In one of the cases I cited, it was teenagers who said that they had smoked marijuana and they knew the effects of being high. If you look at the cases across the country that have allowed lay testimony from a police officer, and they cite Rule 701, if it has,
Well, let me ask you this. So if someone's walking down the street erratically, I mean, the police officer couldn't get on the stand and said, I saw him walking erratically. In my opinion, he was high on marijuana. How would the officer know that? There'd be no foundation for that.
Exactly right, Your Honor. And again, there would be a foundation, so the police officer would say, I saw him walking erratically, but was there something else? When I approached him or her, did he smell of the marijuana? Did he admit that he had smoked marijuana? Was there marijuana on his person? All of those things come in to establish that marijuana or whatever, in some of the cases it talks about having a prescription for an opiate, and there were those types of drugs in the car. So all of those things together compromise what the government is required to show with regard to the type of drug.
Let me ask you, I'm sorry, finish your answer.
That was my answer, Your Honor.
Okay. This is usually, the point of Daubert hearings, I think, is it's a gatekeeping function to decide, can an expert testify to a particular scientific proposition, causation, whatever it may be. Here, you're going one more step. It was a hearing to establish, not that an expert can testify that there's a link between performance on field sobriety tests and driving capacity, but I take it that it is sufficiently, well, that's the question. But we're asking lay people to do that as a matter of common knowledge, and that's where I'm having some trouble.
I think the problem in the trial court, Your Honor, was that they had this hearing to determine if an expert was required, but as it came out, and how the questions are reported was more to a different question, which was, may a layperson testify to these signs and symptoms of marijuana? So while it was called the Daubert hearing, that's not really what it developed into, and that's certainly not the way the questions were reported to this court. It was more reported as, with marijuana, as with alcohol, is a lay witness permitted to testify to the signs and symptoms of marijuana intoxication? And I would suggest to you that, and with particular the standardized field sobriety tests, those don't test anything that's of scientific basis, so an expert is not required. Standardized field sobriety tests.
That's with respect to alcohol, though.
Pardon me?
It's been established with respect to alcohol, and that's the basis why you don't need to have an expert.
Yes, Your Honor, and I would suggest to you that the testimony in the lower court here established that it's not required for marijuana, as well as did the record appendix was filled with studies that established that across the board, at least with regard to the one-legged stand, that absolutely tests for the relationship or the correlation between marijuana consumption and a person's ability to have balance on that test.
Was there any evidence that a state trooper could obtain, or a police officer could obtain training such that with knowledge that a person had consumed marijuana, and depending on what a subject's performance was on the field sobriety tests, that the police officer could express an opinion as to whether or not that person had been operating a motor vehicle under the influence of marijuana?
Trooper McGarrian testified that along with the training that cadets receive at the police academy for OUI liquor, they also have a block of education that they receive with specific regard to marijuana and drugs and their how to determine whether or not someone is under the influence of marijuana. And part of that includes the standardized field sobriety tests, and another part of that includes other tests that are given to defendants or drivers that are more sensitive to marijuana. The Romberg balance test, the finger-to-nose test, and nothing prohibits a police officer from doing those additional tests roadside in conjunction with the standardized field sobriety tests. That's been done for years with alcohol intoxication, and Trooper McGarrian testified specifically to the training that cadets receive at the State Police Academy, and that he also gives that training to local law enforcement agencies. So I would suggest to you that they do receive that training with regard to intoxication specifically for marijuana.
And that it impairs operation of a motor vehicle?
Yes, Your Honor. And there was also the study in Canada that looked at over 2,000 impaired drivers, and those were field studies, not studies that were done in somebody's office, but these were in-field studies. And that was the Porvath study, I believe. It was over 2,000.
What year was that? Because there is the 2015 study that was done by the Highway Safety and our own field study of 2,000,
The one that I'm
3,000 crash.
The one that I'm referencing, Your Honor, is 2014, and it's a PORAF study from Canada. And that looked at over 2,000 drivers who were picked up for being under the suspicion of alcohol or drugs. And there, the police officer evaluators looked at the signs and symptoms, including the one-legged stand, and then the drivers were then taken back and they were given a blood test. And the accuracy of the police officers to determine impairment was over 95%.
So their impairment, what they were observing, was the inability to stand, as compared to the 2015 test of 3,000 crash-involved drivers in Virginia Beach, comparing them to 6,000 control drivers. That was where they were testing impairment, resulting in accidents.
Well, that's resulting in accidents alone, Your Honor. Just because somebody's impaired doesn't mean that they have a crash. Your ability to be impaired or to drive, as with alcohol, doesn't always lead somebody to crash their car. It's just their ability to react.
Needs to be correlated to the inability to drive or not.
Yes, Your Honor, and I think that
Ability to drive or the level of intoxication?
well, you have to show that you have a diminished capacity to drive, and in Massachusetts, the jury instruction is that you have to have a diminished alertness and a diminished ability to respond promptly. And I would suggest to you that there was more than ample testimony here that one of the main things that marijuana causes is problems with reaction time and problems with having your attention divided. And so when you look at what the Commonwealth is required to prove and what marijuana consumption causes, I would suggest to you that the testimony about field sobriety tests is more than relevant.
All right, thank you.
Thank you.
We'll take our morning break.